Good afternoon, and thank you all for spending some time with us. My name is Dave Sherwin. I'm a professor at Cornell School of Hotel Administration, which is part of the Cornell's College of Business, and I'm the director of CILR, the Cornell Center for Innovative Hospitality, Labor, and Employment Relations. It is the world's longest title of a center. We're here today to talk about a number of issues pertaining to people coming back to work as the pandemic hopefully winds down and the economy picks up. There are a lot of issues that employers are dealing with, and we have an excellent panel today, and I'm thrilled to have these folks with us. So let me introduce our panel. We'll start with Eileen Berman. Eileen is a founding partner of a new law firm called the Continuum Legal Group, based in Atlanta, Georgia. Eileen has been a lawyer for at least 30 years, doing labor and employment, and more importantly, she's my classmate from Cornell's ILR school from 1986. So Eileen, it's great to be hanging out with you. Thanks for being here.
Thank you.
Our other panelist is Zev Eigen, continuing in the Cornell, I guess, incestuous relationships. Zev is a graduate of also the ILR school and was a student in the first class I ever taught in 1994. He then went to Cornell Law School, got a PhD at MIT. After being a lawyer and a professor, Zev founded Syndio, a software analytics provider that gives insight to allow companies to prevent pay inequities due to gender, race, ethnicity, LGBTQ, and other categories. So we've got a practicing lawyer, a data scientist, to handle or address issues, again, of people returning to work. And so let's get right into it. If we look at the June job reports, 850,000 jobs in June were created. But when we talk with anecdotes and also signs outside businesses as we drive by and we see help wanted, I recently saw a McDonald's that said, the restaurant is closed, we can't find any employees, which was kind of an interesting sign to be out there. So we've got this labor shortage as well as demand. And we've got this other issue going on that I want to start with, which is that for the last year and change, a whole lot of people were working at home and enjoyed working at home. Or if they didn't enjoy working home, now that they're being asked to come back, they're realizing they did enjoy working at home. So as we're looking at employers trying to figure out how to bring people back and how to come up with some sort of system for those that wanted to work at home or needed to because of childcare and other issues. I'm going to start with Eileen. Your firm represents a number of employers, and I'm sure many of your clients are calling you up saying, how do I deal with my employees who want to work from home? So what are the issues that they're asking? What are the responses and the advice you're giving?
Sure. Thanks, Dave, and appreciate being on this panel. The key word that keeps coming up is flexibility, and getting employers to start to think outside the box to entice people to come back to the workplace, or to continue to work remotely in a way that promotes the business's culture and productivity and quality and other things that are essential to the success of the organization. And so the questions that I've gotten, and I was thinking about what are the main issues that have come up in the last 3 months as the pandemic hopefully is subsiding and people are reopening and starting to get back to work, is one is being able to have that flexibility of allowing employees to work from home, either on you want shared expectations. So you want to lay it out there and make sure they understand what is expected of them. Is it once a week, once a month, 3 days a week, or as the business needs you to return to work. But having that flexibility, but communicating to your employees what is expected will help people understand, what lies ahead. The other two issues that I've had come up recently is, how do you measure performance? We do annual performance reviews. They're usually done at a certain time each year. And what did we do last year? How do we measure employees' performance in 2020 and part of 2021? And a lot of employers were asking, do we go back to the formal performance standards when we don't see people every day and we don't interact as often? And so it's something that employers need to come up with some effective mechanism by which they are measuring performance. And it's a new world. It's not what it was a year and a half ago. And so thinking about how we measure performance when we don't see each other every day, or we're on a flex schedule that never existed before, something that employers need to take into consideration. And then the last thing that I think is going to come up is when we have a flexible work schedule or a remote work schedule that is a request for a job accommodation under the ADA. So, for instance, an employee brings a medical excuse from their psychiatrist saying they need a permanent work-home job. And the employer says, well, no one on your team has a permanent return to work, permanent remote situation. They work 2 or 3 days a week from home or as business needs, but it's not a permanent. And the employee says, well, I was successful during this trial period, if you will, the last 15 months, working from home. I've met all my performance standards. Are you denying this accommodation because you are saying it's an undue hardship? Even though the track record for the last 18 months, 15 months is that it wasn't an undue hardship. And so we have to consider what is an accommodation, especially if it involves working from home in the post-COVID workplace. So those are a few things that have come up with me recently with clients that we've explored.
The legal issue that you brought up at the end is interesting. I'll see if how good Zev's memory is, because when he was my teaching assistant in the 90s, we did a case out of the Seventh Circuit, Van Zandt versus State of Wisconsin, where the Seventh Circuit held that working at home was an unreasonable accommodation. Again, it is in the 90s, and they're saying, but the court said, at this point in time, working at home is unreasonable to ask to work at home. We're not saying this is going to be it forever, but it is now. 20-something years later, and after a pandemic, it's an interesting argument to say whether it's reasonable or not, and whether or not an employer can say, it's my culture, it's my value proposition being here, whether that's going to be essential or not. And I'm guessing that as lawyers, we're going to look and say, we don't know what the courts are going to say on that, and we can't advise. While Eileen was talking, Zev, you were nodding along at some of the things she was saying, and I was always thinking about the times we've been on panels and so on. You always, when you were a practicing lawyer, sort of had a simple view of employee policies. We treat people fairly. And that was sort of your mantra. How do you view the concept of somebody saying, I want to work at home? The employer, you are an employer now with 70 plus employees. I don't know what your opinion is about having all your employees work at home, but I know that there is synergies from being at work. There's mentoring, there's training, there's impromptu discussions and innovations. What do you see as an employer, advisor, and an employer about people who want to work at home?
Yeah, thanks for having me on this panel, Dave. It's always fun. I think we're moving towards first of all, what is reasonable now is very different than the 90s. And Dave, you got to stop mentioning the 80s and like you're not doing any favors to Eileen and me. Like it's okay.
Not at all.
You can leave the dates out. It's like, oh, and Zev was a student in 1923. It's like, okay, we don't need that. But for sure, what is reasonable now is definitely not. I don't think Van Zandt would stand up for 10 seconds these days, given the fact that we've all worked from home for about a year because of a pandemic. So I think, there's always trade-offs too. I mean, just as an employer and someone who's talking to a lot of clients all the time about this, everything is a trade-off. Certainly in the hospitality, it's certain industries, right? Hospitality, retail, restaurants, you have less flexibility than you do in industries like ours, like tech. I mean, Syndio, we do a lot of our work online and on a computer anyway. Like most of our discussions with clients or with prospects or even webinars like this, I can do sitting in my home in front of a computer. And we have a distributed workforce. We have 2 hubs. We have employees mostly in Seattle. We have some in DC, and we have some in New York. We have Seattle and New York are our 2 biggest hubs. So we have sort of like home base office. And I think a lot of companies are moving more towards this hybrid model of having some shared space to get some of the benefits you're talking about of like, coming in and having innovation and face-to-face. We just did one of the new products we're developing. We had a whiteboarding session. We were all in Seattle. And it's really the first time since post-pandemic where we're able to do this. We had a board meeting, and then we dovetailed it with some in-person meetings in Seattle, and it was great. Like for me, it was the first time doing that since pre-COVID, really, where I missed it. It's so productive. It's so great. Like everyone in the room together is so much different than being like this and saying, "Oh, what do you think about this picture?" Like sketching it. Literally, before this, I have notepads, and I'd sketch designs, and I'd show it up to my designer and be like, "Hey, what do you think about it? What if we have this on the screen?" And that, it's not the same. And those trade-offs are hard. There's legal issues here too, obviously, that Eileen's highlighting about managing expectations. There's pay equity issues, like how people are regarded in terms of their contributions, in terms of how they're evaluated, both internally and externally. And one thing that Eileen said, which keyed up an interesting point for me, is the lack of in-person shifts what has already been happening pre-COVID from really what I'd say is like a subjective way of valuing how people are their contributions to work to more of an objective and data-driven approach. Now, you can say that's good, you can say that's bad, you can say that's happening in whole or in part, but there's definitely more of a shift away from subjective valuation of contributions and KPIs, more towards an objective data-driven approach. And again, you can debate whether that's good or bad and whether that's applicable in some industries or not, and what effect that has. But there's more transparency that's associated with that and more ability to analyze and assess whether the data are being evaluated systematically and in an unbiased way.
Yeah.
Eileen, I follow up on that. And also, Zev raised, you've got the issues, and you brought it up of judging performance. But I want you to respond to Zev, but at the same time, I want you to think about, in addition to sort of judging performance, one of the issues that I've heard from employers is the frustration. They call their employee who's working at home, and the employee doesn't pick up the phone. And part of working at home is I'm going to the kitchen to get something, or I'm taking care of my child, or I'm doing an errand or something like that. So how do we manage that? Or are we saying you must be there, at your chair for those 8 hours? And then there are wage and hour issues for people who aren't exempt, because we're not monitoring and checking in, and they took off for an hour and we didn't know. And so all those things, what's your advice, or what are the issues you're seeing?
It's a lot there to unpack, Dave.
Yeah, I figured I'd give you an 8-part question.
Let's go to performance standards, right? Because at the end of the day, that's what we usually judge. We use to judge on compensation and promotion and development and progression in the organization. And you've got to set clear, specific standards, whether you're non-exempt or exempt, on work quality, on responsiveness. Again, in the context of working from home, right? Productivity, all of that has to be probably better explained when people aren't coming into the office every day. So I think good advice is to start with with some type of either goals or measurements, benchmarks for employees who you're being flexible and allowing them to work from home. You're allowing them to attend to dependent care, child care, other things that we've all had to focus more on during COVID because we were all home and there were no places for our dependents to go. And I think that there's going to be a demarcation in what we knew and what we know going forward after Labor Day. So it's a good time to start to prepare as an employer, especially in HR professionals. And that's kind of a new year, right? It's a new time where people are going to come back to the office, we hope, if that's what our employers, our clients want, enticing people to come back to the work site because of the innovation opportunities, the collaboration that you just don't necessarily get through a Zoom call or working alone all day. And set expectations and hold people to those standards through periodic check-ins and performance evaluations and constructive feedback and things like that. You don't want your employees to be out in silos in the atmosphere where they're not being contacted and engaged as a productive member of the organization.
And it's interesting as we're looking at this with employees and coming back, not coming back, if they're what the employer wants, what they want to do. But then there's another aspect, which is the client or the customer or whomever they interact with. I think for the last year, we were all incredibly nice. You're on a Zoom and you're paying your lawyer $1,000 an hour and their 2-year-old jumps on their lap or their dog is on their shoulder and everyone's like, oh, what a cute dog barking during my $1,000 an hour call. Because that was life. I'm not so sure that going forward, that when you're paying your consultant or whomever it is, that kind of money, that you're going to think the child, the dog, the cat or whatever is so cute while they're supposed to be focused on what you're doing.
One of my clients instituted a performance metrics that the employees were judged by pass fail and pass plus. Okay. So, it was, you passed because, you answered the phone 9 out of 10 times when I called, or you didn't have the interruptions as many times as others. Pass pluses, you were what was the benchmark of expectations. I just think that we were much more lax, and that's going to change because there's alternatives now for pet care, daycare, children care. None of those were there for a year, but employers are now expecting that you've had the time to arrange for that. And that's another word of caution is simply, oh, by the way, my dog literally just came into this room. It's like I'm cute. But you take this time before school starts to set those expectations that you need to arrange for the care, the things that you've taken for granted over the last year by working from home, so that you're ready to be if this is what the employer wants, on-site, productive employee. And certainly in the service industry, as I've mentioned, this is almost impossible, and an almost impossible remote policy to have in place. You just can't.
Zeb?
Yeah, obviously, I think there's more kind of issues with people who are impacted, who maybe have less means to manage those kind of things, and especially with childcare, dogs less so. But and you're right, Eileen. So during the pandemic, if all our kids are working from home, and people with little ones are dealing with that, I think there was sympathy and an expectation around just dealing with that because we're all in this together. And I get it. Your kid just. You're Zoom schooling your kids at home. They're 3 years old. What does that mean? That means they're going to be all over you, and that's how it is. So when schools open up again, hopefully in the fall, I think the expectations need to be recalibrated a little bit if people remain working at home and the schools are not, kids are back in school. But obviously, like, we have to be mindful of the impact that some of the changes in these policies can have, especially on working women. We've seen a lot of statistics from labor economists, some of our own, like some of the folks we have at Syndio who've done some studies, and other people. We've seen reports that the pandemic has more drastically impacted women and people of color, especially in lower wage earning positions. And some of that has to do with childcare obligations and responsibilities, or other related things. So I just think it's wise for employers to be mindful, not just of the legality of policies and their impact, but just, again, like Dave said, I am a fairness person. Like, I think it's important to think about the law, but also think about just being human and being fair to employees as well.
And I would just add that I think the statistics are not only that it's impacted women and that they've carried more of the burden during COVID, but also they're leaving the workforce.
Correct. Yes.
Decision to leave the workforce. And so, to your point, Dave, we're just having this glut of of a lack of employees to fill these positions, open positions, is employers to be mindful of how flexible you can be to entice women to come back to the workforce, whether that's providing childcare or more flexibility, or childcare referrals, and giving them opportunities to be able to juggle both. And I think that's a really important point.
We've seen a lot of employers doing that. And by the way, that dovetails with pay equity, because why would you ever work at an employer who's not paying people equitably and fairly based on race, gender, any other protected category status? So we've seen some employers, especially in hospitality, in the restaurant and hospitality, some of our customers who have been more forthright about their use of Syndio, or their attention paid to remedying and staying in compliance in terms of pay equity, in part because of the need to attract and retain. Retention is also really critical. Attract and retain top talent, especially women, because they've left the workplace in the pandemic and they're trying to get them back. This and pay equity is something that actually, based on the evidence, is a 5x draw over paying market. So one thing that we've seen is, like, if you're worried about paying market and worried about paying people internally equitably, the internal equity is actually way more important based on the survey data, especially recently, which makes sense, because if you think about it, if I told you, hey, Eileen, the company you're working at, well, it's your own company, but say you were working at a giant law firm, and I said, hey, Eileen, the law firm's paying you less than market. You go, oh, well, that's crappy, but like, okay. If I said, hey, Eileen, the law firm pays you 30% less because you're a woman, you'd be like, burn this place down. I'm starting my own firm. Like, I don't want to work here anymore. And that's a normal human reaction.
Sure.
Like, so that's why you see that like 5x difference. Like, market matters, but like, treat people fairly internally, then that's a very different kind of value proposition and psychology for your employees.
So let me bring us back a second, because you jumped ahead and
Sorry.
We had a perfect segue, but of course Zev jumped in before I was able to do my segue. But what we're talking about now is we went from talking about working at home, but the term that is now what people are speaking about all the time is we need to be an employer of choice, because there's such a demand for employers that we need to be an employer of choice. And which was where we were segueing into pay equity. And pay equity, and Zev, it's your world, so if I screw this up, interrupt me. But it was something that years ago, there were some state statutes and rumblings about federal law, and that this was going to be the next big legal issue. And while it's out there as a legal issue, it hasn't really become such the legal issue. Not that there aren't many companies who have gotten whacked and really need your services. But what you're saying is that, I'm paraphrasing, but to be an employer of choice, it's nice to pay market, but it's vital to pay fairly within your own doors. And if you don't, then that's going to prevent you from being an employer of choice and more likely lead to an exodus than if you were a little below market, across the street, because people don't like to move in general, but they are when they think that they're being treated unfairly in their organization.
It's a great way to put it. And I would say, I would make it even what I've seen and we've experienced at Syndio is when you have that exodus, you very rarely hear that in the exit interviews. Like very rarely will you have women, and it's often people of color as well, who are leaving. And in an exit interview say, oh, I'm leaving because I'm paid inequitably. They very rarely disclose that. And we have instances of employers in several industries, including hospitality, where after the fact, they've learned about it because of a complaint or a lawsuit. But you ask them like, well, hey, did they say anything at the exit? No, they never mention this at the exit interview, that they found a paper on the photocopy machine with people's comp. And they're like, oh my God, I'm paid like 30% less than men who are doing this same job, or people who are, lower than me on the corporate hierarchy, or get males who are getting paid more, stuff like that they discover, the smoking gun kind of thing that someone left in the copy or digitally left it available. So you don't really even see it. So you might be losing talent, and the ones that don't blossom into lawsuits or complaints, you might be losing talent if you're not doing this. Plus, getting ahead of this, even if you're not sued, getting ahead of this, not just thinking about the legal risk, but again, it's about attracting and retaining talent, and that component of this is really critical. But the law, yeah, you're right, Dave. So the law, there's federal law on the books since 1963 that is very broad and hard to enforce. Or sorry, it's so narrow. Excuse me, it's so narrow it's hard to really enforce, and there's not a lot of teeth. So you got to look at people in the same establishment. So if you're Starbucks, for instance, a plaintiff's counsel could only sue for one Starbucks, not the one on the other corner. The barista's there. So it's looking at people doing equal work in the same establishment. It's a very narrow constraint. So states recently, in the last 7 years-ish, a lot of them, 40-ish states, have promulgated their own versions of pay equity laws that make it easier and more attractive to bring suits and complaints. And those laws have since expanded to cover additional protected categories, so not just gender, but race and other protected categories. We could talk about that. They've expanded to require more transparency, more requirements on the hiring side, not to ask about previous salary, so transparency protections, and also whistleblower protections, anti-retaliation protections, to make these laws more robust. And to really encourage employers to shine a light on this issue. So we have seen a lot of lawsuits, but we've also seen a lot of employers say, look, I'm going to use this as motivation to do the right thing and treat my employees equitably and fairly, whether they're worried about being sued or not, frankly. So obviously the law is an important component. I think it's a big motivator. And by the way, globally too, you see movement globally in the EU as well, and other countries. But for sure, I think this is a time when, when you look at survey data, even people who identify as cis white males entering the workforce, younger generations, they report pay equity as being a really important issue for them, or treating people fairly and equitably as a really important issue for them when they think about who an employer of choice is, when they're picking employers. And then you have that's the bottom up, and then you have the top down. So you have a lot of pressure from the corporate side and the ESG side, from stakeholders at the board level and the public, to really put pressure on employers to be employers of choice. And this is part of corporate social responsibility, is paying people fairly and equitably is, to me, the linchpin of how you treat people fairly and equitably, because compensation is the value proposition that we're all talking about. An employer is paying you, human being, money in exchange for your time. That's the exchange. So what a slap in the face to say, I don't value your time the same as I value someone else of a different gender or race. There's no bigger slap in the face. It's very personal, it's fundamental to that social relationship and that responsibility employers have, they owe to their employees and the public.
So I'm going to put my employer hat on, but not that I am one, but I'll put the employer hat on and say to Eileen, okay, but Eileen, I heard what your friend Zeb just said, and you sent me his video and it made a hell of a lot of sense. Here's my problem. I'm so busy that I had to hire 10 people, and the market has shifted so much that I had to pay them a lot more to bring them in. And now, if I'm going to get pay equity across the board for my firm, whatever my firm is, now you're asking me to give a pay raise across the board that's going to raise my labor costs by 7%, which is my profit margin. So now I'm in, so now I'm in a break even or lose situation. How are employers dealing with being equitable with a market that's driving prices up? And are you facing that, Eileen, from your clients? And then I'm going to go back to Zeev and say, Zeev, you live by this. This is what your company does. How do you respond?
You're throwing these really fastballs at me. I mean, that's a real difficult scenario, right? But that's reality. And I think employers should not shy away from the pay equity piece because they're afraid of affecting their profit margin, because that's just a short-sighted way of looking at retention, compliance, a number of different hiring issues. So I think that your scenario is a law school exam question, and because it brings in a lot of questions about whether an employer has a defense to an equal pay claim, is market factors, right? And that you'd have to frankly call your employment lawyer and run that by them and say, how do we solve this? Do I have a defense to not increasing the lower wages of similar work or the same work because market factors are affecting my ability to hire employees? And then you call Zeev and you have Zeev run the numbers and try to find a practical solution that's in compliance with the Equal Pay Act, with market factors, and all the other non-legal issues such as hiring and retaining. So I don't have a definitive answer on that, but I will tell you that it's an issue that affects both in-house lawyers and HR, right? HR has to be involved in making sure that they identify these pay differences and are able to come up with solutions as to how to treat people equitably. And that involves doing a pay audit, but how does that affect our hiring abilities? So you can't look at it in a vacuum. You have to look at it as a whole. And I charge HR and your comp committees or your compensation experts within the organization to be a leader in that conversation and bring in legal, once you kind of come up with what you think is a practical solution to these multiple problems that if they overlap, they intersect each other.
Zeev, comment?
Yeah, no, Eileen's right. So let's say, a couple things. First, market rate payment isn't something that should inure a benefit to one gender or race over another, right? So the general rule of thumb is an employer may exercise discretion in paying people market, lower market, higher market, as long as that discretion isn't exercised in a way that is discriminatory. So when employers tell me, oh, we had to pay Joe more, he's the hottest person on the market, if we didn't, we'd lose. Okay, cool. Look historically over all those special snowflakes, you had to pay more, otherwise you'd lose them and the sky would fall. Check it. If they just happen to be all white men for the last 20 years, that you had to pay them, otherwise the whole business collapses, maybe check yourself, because that's a problem, right? So by random chance, the people who are the hottest person on the market that you have to have and you should always get shouldn't always be white men. If it's always white men that you have to pay market to, that you have to overpay to get them in, maybe reevaluate your priorities and hiring process, because that's an issue there. And then secondly, this is, one of the reasons why we built part of our software is called Payfinder. And what Payfinder does, it allows you to make on-the-fly decisions based on current data. So if you have hiring managers or recruiting managers, what Payfinder does is after you've run a pay equity analysis, it has all of your information current, up to date in the software. And then if Dave is the hiring manager, he has a view on his dashboard that would allow him to see, based on all the current information, just the specific ranges that the head of HR, Comp and Ben, wants him to see to be in compliance with the group, the pay equity range. So let's say the equitable range for hiring the store managers for Dave is between 60 and 80, right? And the math does that. It'll show him that bar. And market is there's an overlap there of market, let's say 70 to 100. Dave, as the hiring manager, could see that intersection of those two bars in the tool and go, okay, actually, we can thread this needle. We can hire someone in market within the range. And if it's outside the range and he has to go above, at least then you can see it, flags it. And then the Comp and Ben person, the head of HR legal, can see that there's an exception that needs to be made, because what may be the case, it may be a cost model, right? Because let's say you've got to hire Joe. He's the hottest person on the market. You got to hire him and it's over that range. It doesn't overlap. It would flag it. And what does that mean? It means market isn't a benefit that inures just to men. So the cost of hiring Joe isn't just the extra 30K or whatever it is. It's also, the tool will show you this. There's also, let's say, 3 women at the bottom of the range who need to come up too. So you're going to pay Joe 30 more to get him in. And the cost model is, you can see, we got to pay 2 people more. And I'm making up numbers, 5K to bring them up. So you could say to the hiring manager, the cost of hiring Joe is 30 plus the 5. That's because you got to pay these other 2 people more. So you're always in compliance. You're always hiring in a way that's mindful to both market and these constraints and these demands. So again, this shouldn't surprise anyone that technology fundamentally alters some of these problems that Eileen's mentioning are hard problems, and without the software, without technology, it's hard. And it's hard to manage this for companies, but that's why we built the software the way we do. And that's exactly the problem. One of the problems that this software solves, it addresses.
What I was going to add is that it does address that issue. And even without the software, just educating your hiring managers on how the differences of pay within the genders and within the race, so that they're aware that, or even just understanding what people's comp is, and being able to look at that and being alert and aware, thinking about at front of mind, well, we pay people in this group this range, but it looks like most of the women are on the bottom end of the range, and we're about to hire another person and it's a man, and we're already in the middle towards the top of the range.
Yep.
Maybe just to keep that front of mind, gender and race, and other factors if they want to consider them. But if no one's talking about it and no one's thinking it through or having that data and information, it's going to get lost, and they're just going to think about that one hire and move on to the next hire.
Well,
you need a systematic approach. Yeah.
Yeah, I think that one of the things that we as a society of employers have to accept is that fairness costs money.
Yeah, absolutely.
I was doing a roundtable, 10 years ago with a high-level person at the EEOC, and I made the comment that the Americans with Disabilities Act was a government transfer program. But the government was saying to private employers, you have to spend money to accommodate people with disabilities to create opportunities for a marginalized group of society. And this person from EEOC was really angry at me for saying that, and responded by saying, you're saying that's a bad thing. I said, no, I think it's a good thing, but it does cost money. And what you're saying, what I'm hearing from both of you is, hey, look, you do this fairness. There's a legal aspect, but there's also a morale aspect. There's a productivity aspect. There's everything else. And if that means you have to raise salaries across the board and pass that on to your customers and clients and so on, that's how it works, as opposed to having huge disparities that's going to cause more problems later on. Zeb seems to be wanting to say something. So
there's a measurable ROI there, right? So like for sure employers can see like, okay, if and it doesn't require you to pay market. Like there's no requirement here to pay market. But if the demands of business require you to have that cost model, like you're describing, the fairness costs money, but there's an ROI there, right? Because you're you should be able to attract and retain talented everybody, way, reduce and avoid legal risk, et cetera. But on your point, Dave, on the fairness cost money, and it's a shift, that's explicit in the notes for many states in the pay equity laws. Like they literally, a lot of them say, like in California, for instance, California's Fair Pay Act, in the legislative notes in the history, they said here's like, oh, I'm going to paraphrase. They said, look, labor economists have observed historically that there's gaps in the market, even when you control for factors like you call it unadjusted or adjusted gap within certain professions, a lot of professions. I don't know the cents on dollars, 92 cents. You can hear different statistics, but they say if we take those statistics as a given, that's what's happening in our world, in our society. We are intentionally placing the burden on employers to correct that. And part of the way they're correcting it is by saying you can't, this is one of the rationales for not asking about previous comp, because it would just kick the liability can down the road. If I say, hey, Eileen and Dave, I'm hiring you both as lawyers. How much you make at your past law practice job? And Dave was making more than Eileen because of that gap. And you just tell me, well, Dave says I made 100. Eileen said make 80. Okay, I'll just pay you plus 10 to both of you. And guess what? Now we perpetuate the problem. Intentionally, the laws are saying, look, we observe that. Don't do that. And employers, you're now on the hook to correct it right now, starting now. So there is a price, there is a cost of fairness. It is exactly like, this isn't like implicit, it's explicit that the intention of these laws in the United States are designed to burden with employers, to put the onus on employers to straighten up and fly right and correct those imbalances.
I have a question from Mackenzie, who I'm gonna answer it and then see what you two say if I got it right or not. And so Mackenzie's saying that that an employer offers tuition reimbursement as a benefit for new employees, but not current employees, and is that unlawful? My gut tells me that if it's an ERISA plan, such that there's no taxes on this benefit for the employer with payroll taxes, for the employee with income taxes, then that would be problematic to offer to some and not the other. ERISA has all its rules that are way beyond my knowledge. But I think if it's an ERISA plan, you can't do that. If you were doing it as not an ERISA plan, it's just like a signing bonus for new employees. I think you have all kinds of morale issues. And if you happen to hire only white guys as your new employees, or only fill in the blank people, and that looks different than the rest of your staff, that's a problem. But if your new employees look like your current employees, it's a morale but not a legal issue. Eileen, you were nodding, so.
Yeah, I mean, I think you hit the nail on the head. And, consistency, uniformity for the ones that you're offering it to, not to some and not offering it to others is problematic. I'm talking about new hires. And then, of course, you look at those who are already there, and if there's a distinction between who you're hiring and who's already there, and it's based on a protected category, that's a problem.
Yeah. I mean, I agree with all that. I think of comp from a pay equity perspective as just a big bucket, right? So any form of, I think of it as total annualized discretionary comp, right? So you put it in a bucket and you say, and again, this is from the legislative notes, employers can't circumnavigate the obligations of the law by calling one form of comp another. And this is consistent with other interpretations of like wage and hour laws and other laws. It's like you can't call something a bonus. And oh, look, I tricked it. It's not wages. It's anything that's annualized. Look at annualized discretionary comp. It goes in one giant bucket, and that's what you're looking at, because you can't cheat. You can't like avoid the problem by calling one form of comp another, or calling this, I'm going to give this a discretionary cell phone allowance. Like, it's comp.
Right. It's comp. But again, if just to new employees, old employees aren't protected unless they are. Right. And that's because of their protected classes, not because their status of being there for 6 months or 6
weeks. But you don't want to be short-sighted on hiring and ignoring retention. So it's something to balance,
You could, what I'm saying is you could remedy it by offering a comparable cash bonus. Right. I'm saying, like, cash is cash. So like if you said, okay, if you looked at it and observed the problem, I think you could remedy it. But I guess I'm asking both of you, wouldn't it be okay for an employer to say, okay, well, we notice this is an issue, so for older folks, we're going to give them a cash equivalent benefit or bonus or something?
No, you can, and I think you could also do it. You could offer this tuition to everybody. The way companies look at Cornell, we have a tuition reimbursement benefit, and the person with no kids subsidizes the person with 7 kids.
Right.
Because but Cornell has decided that education is important, and they want to help all the employees from the president and the provost to an hourly person who works in the cafeteria, and they all get the same benefit. But again, we don't, depending how many kids you have, you don't get the same benefit. So, but I think that's fairness. What you can't do is base it on obviously race, sex, and so on. So I think that what this person, what Mackenzie was asking, was more of, is it fair to the current employee?
Yeah.
And the answer is, it's not fair to them, but it's not unlawful.
Right.
But I think Eileen made the point. Retention is just as important as attraction. Because
guess what? They could leave, go to another employer who's offering that. So you've just lost an employee, and the costs associated with retention or attrition, there's just a lot to be thinking about, not just being short-sighted, like we got to get people in the door. And maybe they have to. Maybe they need bodies like McDonald's and needs to hire people to open their doors.
But I think, sorry, it's a standard adverse impact matter, right? If you have a neutral policy or practice was an adverse impact, like you're paying attention to that. So I think that part is, we're all saying the same thing. You got to analyze that, and the ERISA, obviously, I think those are like you got to do that stuff. But I'm curious, I guess, what's the how can you fix it prophylactically if you observe an issue? Because and Dave, I mean, in academia, it's a little different because that's like the ice cream store giving away free ice cream or discounted ice cream for their employees. Like you're an academic institution.
Yeah,
and
but not really. I mean, the university literally sends money to the other universities that the children of their employees go to. So it's not just, when the student goes to Cornell, you're right, it's just funny money. But when the student goes to, you're out in USC or Emory, then they're sending cash money.
Yeah.
So I'm changing the subject just because we're getting close to time. So, more than a year ago, we had a case came out dealing with whether or not the term sex in Title VII of the Civil Rights Act of 1964, whether sex also included sexual orientation and transgender. And having us all known each other for a long time, but Zev says I can't say how long, so I won't say it again. But we all talked in different times. We've been on different panels in different places where we said it's about time for Congress to amend Title VII to include sexual orientation and transgender. And I have memories of us having these discussions and agreeing with that. The court did it because Congress doesn't do much. So the court did it instead. When it came out, the more progressive folks and certainly the LGBTQ community was celebrated. A lot of employers who were progressive looked at it and said, not a problem. We believe in this, so what's the big deal? But I think there are some concerns. So I'm going to start with Eileen. Is this a no-brainer, or does it lead to potential issues that employers have to address?
Yeah, unfortunately, it's not a no-brainer because Congress did not act. This is really my opinion, but it does not say in Title VII, under a protected characteristic, gender, identity, or sexual orientation. It's not spelled out in any legislative statute. So it's court-imposed, court interpretation that's created the law, which is a great thing. It's about time, but it does lead to confusion, I think. And there's no congressional mandate that, so there's, in the general public, I don't think it's as commonly understood. And so that fell on employers to update their policies, right, and make sure that they included in a protected characteristic under their EEO policy, their anti-harassment policy, sexual orientation, gender identity, gender expression. Whether employers did it or not, is uncertain. There's training that goes along with this type of evolution in the law, and that is an uncertainty as well. And then there's updating just record keeping and applications and just other things that are required as an employer to include sexual orientation and gender identity. And so this is something that's going to take some time. And there was a big push, I think, in the HR world to make sure that employers were updating these types of things. And when Bostwick came out, but hopefully it's continuing and that it becomes a more of a practice and a policy that people understand that sexual orientation is a protected category and gender identity is a protected category. It goes to pay equity, this whole issue of, do we include sexual orientation and gender identity is a form of sex, falls within the definition of gender or sex in Title VII. How do we account for it in our pay equity analysis? And is it something we inquire about, we as employers, upon hire or in just our general record keeping in the workance? And and that's something, I pose to Zev, but I think
let me throw in to kind of frame it a little bit to Zev, because I agree. This is Eileen and I are just lawyers. He's the data scientist, so we'll lead to him. But in the law, in discrimination law, there is intentional discrimination and unintentional discrimination.
Yeah.
And unintentional discrimination has always been proven and litigated by statistics, by numbers. Yeah. So we can go way back to 1969 in the Griggs case, where they looked at the percentages of eligible white people. I think it was 32% of the population in the state of North Carolina for these jobs, and only 12% of the black people were eligible based on being a high school grad or not. And that's what began the unintentional discrimination argument. In order to do that analysis, they looked at white people versus black people in the state, in the state workforce. Many of the state laws on orientation and transgender exempt unintentional discrimination from the analysis because the statistics are hard to gather. As I read Bostock, there's no way you can say that adverse impact doesn't count. That means you can have an orientation or transgender case based on adverse impact. But in order to defend the plaintiff has to prove it with stats. You have to defend yourself with stats. Zeb, what the heck's going on? How does this work?
So this is something that I've seen in pay equity laws as well, and I agree with you on Bostock. So the difference between intentional and unintentional discrimination may be a nuance that is a really important one, but may not be completely in the minds of the folks who are responsible for drafting and approving these laws, our legislators. So in pay equity laws, like if you look at New Jersey's law, in fact, if you look at the draft of the Paycheck Fairness Act, which isn't going anywhere, it has Section 2, I'm looking at it on my screen, enhanced enforcement of equal pay requirements. And it expressly says that sex will include sex stereotype, pregnancy, childbirth, or related medical condition, which, like, wrap your mind around that for pay equity, orientation or gender identity, and sex characteristics, including intersex traits, and orientation and gender identity. So they're saying sex for pay equity will be all of those things. So again, I think some of this is just there's a copy and paste happening. Literally, that's what happened in New Jersey. Like, they're just copy and pasted other protected categories too that are hard to measure, like blood trade and things like that are like, I don't know how employers measure this with data. So they're taking intentional discrimination protected categories, which makes sense, right? I get why under a Title VII regime or state equivalent regime, if you're alleging discrimination based on gender identity, that makes total sense. You got to prove intent. Cool.
Yeah, Zev, let me interrupt for the audience. What we're saying. What you're saying is, if you look and say, oh wow, you're gay, you're transgender, that's wonderful, you're fired. We all get that that's intentional discrimination, problematic, should not happen, violates the state laws that protect it, violates Bostock, and easy for employers to comply with. Don't do that.
Don't do that, right?
Easy. But now when they say that your pay equity can't have any problems, or with gender, with orientation and transgender or promotions or other things, and we're looking throughout the whole organization. Now explain what's going on.
Right. So now it's a data question, right? Thank you, Dave. So obviously that the intentional component is where you don't need data because you're trying to, the employee and the plaintiff has to prove intent. So they have to prove that the person knew that this person was in a protected category and they took action because of that protected category. Not so with pay equity. Pay equity, especially prophylactically, like think about employers who want to get ahead of risk and reduce risk before there's a lawsuit. You said, okay, how many employers today have data on robust enough data to analyze on orientation and gender identity? And does it create an obligation on employers to poll? Like Eileen said, does that mean employers now have to, congratulations, welcome to Cornell, please fill out this form telling us your gender identity and orientation, and be aware we're going to use that as data for, like, it's mandatory to fill that out. What if employees don't want to share that information with their employers? Do employers have to collect it? So it creates big challenges for employers. I think I don't think that dot has been connected by our great minds in the legislators, both at the state and federal level. I literally think, I'm not joking, I think when I brought this to their attention, they're copying and pasting from intentional discrimination statutes to the unintentional ones, like in the Paycheck Fairness Act. It's a problem. And again, I don't think there's an answer here, but at some point employers will, if these things pass or there's more movement here, I don't have a good answer for employers. Basically, we analyze the data you have. So if you don't have the data and you say, well, what's the risk that we get sued for this? I don't know. I don't have the data. And, luckily you have software. Our clients have software so you can analyze what you have in an ongoing way. So if you get new data, great. But let
me ask a quick question to Zeb.
Analyze what you don't have.
Might be on other people's minds, Dave. But in an EEO-1 reporting compliance, are you required as an employer now to provide orientation and gender identity? Under gender?
Not what's being proposed. So that's interesting. It's a great question. It's not in the proposal for the new transparency regs that are being proposed.
Something to look like. Maybe we'll have another webinar in 6 months or something.
But the thing is, and I think that shows what Zeb identified. They're not asking for that, but they're allowing a claim to go forward because because we don't have legislation that says the legislation that went before Congress that passed the House and lost to the Senate by one vote in the mid-90s expressly excluded unintentional discrimination from, it was just orientation, it wasn't transgender. Again, times were different, but what they excluded that, and what it said in the notes was employers shouldn't have the obligation to ask, and employees shouldn't have the obligation to reveal orientation as just to get a job. Now, maybe we will get to a place in our society where that will be, that'll be like writing down what color your eyes are on your driver's license and nobody will think twice about it. But we're far from that at this point. But
we're a lot further than we were in 90s when you wouldn't even think about it.
A lot further. And if you can look on college applications where there's many things and choices and so on, we're moving there. But the question is, and the interesting question is, if society gets there, does that mean an individual has to be there?
Right.
It's like someone can be ahead of the curve or behind the curve.
Or a private employer has to be there.
Or does a private employer?
And some states do have it. Like California now has, in terms of the boxes, it used to be male, female, now it's male.
I was going to ask, right.
So some states have you're both right. Where the times there are changing, and you see this at the legislative level, at the employer level, at the human level, like the social level.
Right.
And maybe that's right. Maybe just over time these issues will resolve because, like you said, Dave. Yeah, it'll be like this. These are my pronouns. This is my identity, and this is my orientation. You're right. That's one way to think about it. I think too, maybe this is a good thing. Like maybe it's a good thing to put more pressure on everyone to normalize those things.
Well, and the thing is, I think that, and I think we can make the argument. It is a good thing that to normalize, but it doesn't mean that there isn't pain along the way, and along the way, there is the potential for these lawsuits. Now, again, the plaintiff has the burden of the first time, to prove with statistics. So they have to come forward and say, you have a pay equity problem, you have a promotion or whatever problem because of orientation or transgender. So they'd have to come up with the stats, which is going to be really hard. So maybe we're not going to see that. But the EOC can do it. They have the power to subpoena, and the employer could be in the situation by saying, I didn't ask. Well, sorry, you should have asked, because now you have a problem, because this policy that you have is problematic for this class, and you should have known that. So it's just something that's out there that we're likely gonna see before things sort of, again, to use your term, normalize. We are up against our time, so we're actually a minute over. So we are. It's time for last word, and we can go with a last word that is something to do with what we just discussed, or something that we didn't have to discuss. So I'm going to go, Zeb, last word.
No, this is great. These are hard challenges. I would just urge check out the resources we posted. It really takes a village to get these issues right. It's important to have good counsel like Eileen. It's important to have good technology like we offer at Syndio. And again, like how employers navigate these issues, especially with things like coming out of the pandemic, returning to work, and the ever-changing landscape of the laws. Look, you got to have great domain expertise, you got to have great advice, and you got to have great technology. And that's why we put these panels together. I appreciate Dave. And I can never say Kyler. Is that how you say the acronym?
That's how I say it.
Kyler. I wrote down my notes. I'm like, I don't know how to say it. But I appreciate how Cornell puts these things together, because they're always timely. They're always like things that employers need to pay attention to. And so I hope this is useful. Everyone should reach out, because we love to work with everybody. We work with everybody in the entertainment industry and hospitality industry, entertainment industry too. But love to work with everybody.
Eileen.
I think it's a whole new world, as we all have acknowledged over and over again. And being, especially during COVID and the uprise of the Black Lives Matter movement and the George Floyd, coming out of the George Floyd, the death, and social justice being on everyone's minds, it's in the forefront of our minds, is that employers need to be human, right? And employers need to be flexible and genuine and sincere. And your employees are going to demand it. And so don't ignore it. Don't stick your head in the sand. Make sure you're listening to your employees, and make sure that you are being as responsive to them as you can, because of how challenging it is to be the employer of choice.
And on my last word, a couple of things. First, I think that what you see with Eileen and Zeb here is you have a lawyer who understands the relevance of data and technology, and that's part of something that their firm looks at, and that's part of the practice, because to not is ignoring the present and the future. And then you have a company that is in Syndio that is providing software alternatives or solutions for legal issues, and I think that's the future. And so it's a reason to bring all of us together. But that's where we're going. And so I think from both ends, if you're looking for your technology expert, you want to know that they're understanding the legal issues. And if you're looking for your law firm, you want to know that they can tell you what tech is out there to help you. My other thing is, as a professor in a college of business, there's always an argument that the business folks have versus sort of the government folks. The government folks say government solves problems. Business says business is more efficient to solve problems. I'm going to, in my last word, say that the government is constrained with vaccines about telling people what to do, much more than employers are. And as I'm watching numbers rise and mask regulations coming back and concerns all over the country, I'm begging employers to require vaccines of their employees, of their guests, of their customers, of their vendors, If we're going to get behind this, it's going to be with vaccines. The government has constraints much more than employers do, and employers need to get the economy going and keep it going, and this is a way to do it. So I'm asking employers, any of you watching, please use your power, use your abilities to get people vaccinated. Encourage them, require it, but somehow get it done. Zev, Eileen, it's always fun to hang out with you two. I look forward to doing it again at roundtables, at Kyler conferences. Shameless plug, we've got our big conference in September at the Del Coronado in San Diego, a top 10 resort in the country. A lot of fun. Zev and Eileen will be there. So thank you all for watching us, and we hope to see you at the next webinar or at our conference in San Diego.
Thanks, Dave. Thanks, everybody.
Thanks so much.